Good afternoon, everyone. Sorry for getting started a little late, a few technical difficulties. My name's Stephen. I'm with the Flint and Genesee Chamber of Commerce. And, excuse me, got another technical difficulty. Thanks for joining us. Today we're talking about navigating the COVID-19 funding and relief provisions. We're joined by attorneys Megan Parpart, Dan Villaire, and Gina Staudiker from Howard and Howard Law. My name's Stephen. I'll be hosting today. This will be recorded and made available on our website by tomorrow morning for all of you to view. We'll include the slide deck as well. Today's webinar will be focused on labor and employment considerations, tax credits under the Families First Coronavirus Response Act. We will also be discussing state tax benefits as well as loan and grant relief. There will be a time at the end for question and answer, but feel free to use the Q&A functionality to ask your questions as we go. With that, I'm going to hand it over to attorney Dan Villaire. Dan.
Thank you. Okay. Well, good afternoon, everyone. I'm going to start off by discussing two provisions found in the Families First Coronavirus Response Act that affect employers with less than 500 employees. And you've probably heard a little bit about new leave provisions, paid sick time that is available to employers in certain circumstances. So I'm going to, the act itself, we now know is effective April 1, 2020. So the benefits that these new laws provide are not in effect today. They will only begin on April 1st. So let's start talking about the Emergency Family and Medical Leave Expansion Act. This is an amendment to the FMLA. It is a change that adds a type of leave for individuals, which we'll talk about in a second. But one of the major differences between the new law and the existing FMLA is that the new qualifying reason is available to, or is employers with 500 or fewer employees are subject to the act. As you may be familiar with other FMLA leaves, the additional FMLA coverage is limited to employers with 50 or more employees. This is a significant change as far as coverage. The new law also provides that the Secretary of Labor could issue some regulations to exempt employers with fewer than 50 employees, but we do not have those regulations at this time. We expect to have them anytime this week, next week, or when the Secretary of Labor gets around to issuing them. Okay, so that covers your covered employers. Eligible employees. Any employee who's been employed for at least 30 calendar days will be eligible for this leave. But however, the employee must be unable to work or telework in order to be eligible. As you probably are aware, typical FMLA leave has some work and hour requirements. Those do not apply. The employee only needs to be employed for 30 calendar days. This expanded eligibility and employer coverage does not extend to the other FMLA leaves. It is limited to this new type of leave, which we'll get to in a second, but it involves the care of a child under 18 due to a school closure or loss of daycare related to COVID-19. Again, the Secretary of Labor can issue some regulations dealing with healthcare providers and emergency responders. We don't have them yet, so we don't know if or what those may look like. This slide shows you the qualifying need for emergency leave. This is the new category that's been added to the FMLA. As I stated, it involves the care for an employee's son or daughter under the age of 18 due to a school closure or a loss of child care due to COVID-19. The amendments do not add any other type of leave. As we'll talk about in a few minutes, the other provision of the Family First Coronavirus Response Act does add some new leave provisions, but for FMLA, it is only this leave that is added. Under the new law, if you qualify for the leave, the emergency leave, the first 10 days are unpaid. However, an employee can elect to substitute other accrued leave they may have available. And I put a note here, Emergency Paid Leave Act. Again, we'll talk about that shortly, but that does provide for 10 days of paid leave, which could be used to fill this gap. After the first 10 days, the employer continues to pay the employee at 2/3 their regular rate for the number of hours the employee would otherwise be scheduled to work. So it's not full pay, it's 2/3 pay for the remainder of the leave, which would be up to 10 weeks. Because as you know, FMLA leave is typically up to 12 weeks. If an employee has a varying schedule or they're a part-time employee, you're going to make an adjustment to determine the number of hours the employee has worked and determine the calculation for the payment. All paid leave under this new law is capped at $200 per day and $1,000 total. Just like traditional FMLA, an employee who exercises this type of leave would be entitled to reinstatement and restoration rights. There is an exception added, and basically it says that if the employee's position is no longer exists due to economic conditions or other changes resulting from the public health emergency COVID-19, and the employer has made reasonable efforts, and the employer remains in contact with the employee, the employer will meet its obligations and does not need to restore the employee. So here we're looking at situations where the economic situation has changed for the employer while the employee was off on leave, and the employer just cannot return the employee to work. As long as the employer meets these requirements, their obligation has been fulfilled and there's no need to bring the employee back. Notice requirements, much like traditional FMLA, an employee does have to provide notice to the employer. And again, similar to the FMLA, the certain types of leave under the FMLA, the employee is obligated to provide as much notice as practicable, provided the leave is foreseeable. Obviously, if the employee needs immediate leave, you cannot deny them because they can give you advance notice. The Act itself does not reference any type of certification. Again, like traditional FMLA, there is an eligibility form, a certification form that the Department of Labor provides on their website that I'm sure every employer subject to FMLA is using. But nothing in this Act indicates how an employer is to verify or certify the employee's leave or what type of documentation with respect to certification that an employee is to provide to an employer. However, as noted earlier, we may get some regulations, well, we will get some regulations, and maybe it will address this issue. At least that's the hope. Employers are entitled to a tax credit for the amounts paid under this Act, and we're going to talk about that later. Gina and Megan are going to go over these tax credits, but I wanted to reference them in the slide in my portion just for context, so you can see how they fit with respect to this type of leave. Healthcare providers and first responders, there is special treatment for these individuals, and they may be excluded from the Act if that situation arises. would recommend that you look at the act, probably talk to legal counsel, make sure if you're making decisions on who may or may not be subject to the act that you've looked at all the facts and you meet the qualifications for any type of exemption. The other leave provided for in the new legislation is the Paid Emergency Sick Leave Act. This one provides for more instances of leave, and we'll get to those in a second. But before we get there, let's talk about covered employers. All private employers with fewer than 500 employees are going to be covered. Public agencies, regardless of size, will also be covered. And this is not an amendment to the FMLA. This is a brand new standalone law. So although we may look at the FMLA and its regulations for some guidance, those regulations are not going to be binding on the leave under the Emergency Paid Sick Leave Act. And again, we should have some regulations for this act as well that'll help clarify any of the ambiguities that we may encounter with respect to this new law. Employee eligibility. All employees are covered, regardless of how long they've been employed, as long as the employee is unable to telework, or I should say excluding employees who are able to telework and healthcare providers and emergency responders. Just like the expanded FMLA, the Secretary of Labor is supposed to issue regulations, and those regulations could address healthcare providers, emergency responders, and small businesses with fewer employees. Now, we think, based on some other Q&As that have come out from the Department of Labor, that the small business exception is probably going to have some specific requirements, but ultimately you're looking at a business that, if they comply or if it complies, would be looking at possible bankruptcy or not being viable as a going concern. That is probably the showing that a business will need to make in order to take advantage of the small business exception. But again, we don't know yet. We have to wait for the regulations. The reasons for paid sick time under this new law, there are 6 of them, and the first 3 are on the screen now. First one is individual subject to federal, state, or local quarantine or isolation order. Second one, advised by a healthcare provider to self-quarantine. Third one, experiencing symptoms of COVID-19 and seeking medical diagnosis. As you look at number 3, we see that the employee's only obligation is that they are experiencing, the only qualifier is they are experiencing symptoms and seeking a medical diagnosis. It does not say that the employee needs to have been diagnosed with COVID-19 or that they need medical documentation, only that they are seeking a medical diagnosis. The next 4 reasons are caring for an individual, described in one, subject to a quarantine or isolation order, or an individual who's been advised to quarantine due to COVID-19 concerns. Caring for a son or daughter whose school or place of care is closed due to COVID-19. And then number 6, substantially similar conditions specified by Secretary of Health and Human Services. For number 5, you'll notice the overlap to the amendment to the FMLA. It's the exact same language. So we're talking about the same type of leave here. And as I noted before, I think these things are meant to work, these 2 acts are meant to work together, in that you have 2 weeks of paid sick time under this law that can be used to fill the first 2 weeks that are unpaid in the expanded FMLA. So that an employee taking the expanded FMLA for reason number 5 would be able to receive payment for up to 12 weeks if they have that much time available. Number 6, I think this is something that was added to give the Secretary of Health and Human Services some flexibility to add additional reasons if necessary. And maybe when we get regulations, there'll be a reference. But for now, I think you really need to focus on reasons 1 through 4 as for reasons that employees may qualify for this type of leave. The amount of paid sick time available. So for full-time employees, it's up to 80 hours. Part-time employees, it's going to be the average number of hours worked over a 2-week period. There's some additional language here, like we saw in the amendment to the FMLA, that talks about employees with varying hours, or when it's difficult to determine how much time they actually do work on average. Maybe the last a 2-week period is not indicative of what an employee may work over, say, 6 months. So the law provides then, in that situation, you look at the past 6 months. For example, maybe in some periods, employees work twice as much as they do in other periods. So you're going to take an average over 6 months. If for some reason you don't have numbers to look at, the law indicates that you should look to the average hours an employee was reasonably expected to be scheduled to work. So here we don't even know what the employee will work, would have worked, but you're using what you expected them to work. Once the need for emergency leave ends, the paid sick time ends at the beginning of the next scheduled shift. Nothing too surprising there. In the next bullet, this addresses what happens with paid leave that's not used under the statute, and it clearly provides that an employee is not entitled to reimburse type of leave if it has not been used by the time the employee terminates, resigns, retires, etc. So there's no carryovers. There's no payout of the paid sick time if it's not used. And I think when we look at this law right now, we're dealing with stay-at-home orders in Michigan and certainly other states, and it probably has a different application when we're analyzing where employees are. But I think you have to think a little broader than that. This law is going to apply in June, July, August, so there will be employees who have returned to work and will fall into these other categories. So the law may look a little different at that time, or the application, than when we have multiple people staying at home under the governor's executive order. Calculating the dollar amount for paid sick time, it is pretty simple. It's an employee's regular rate of pay or the applicable minimum wage. So you're just going to look at what does this employee normally make per hour in order to determine how much the employee is paid. One interesting nuance is that like the FMLA leave, the employer is only required to pay 2/3 of the employee's eligible rate of compensation if the leave is taken for reasons 4, 5, and 6. And again, that includes staying home to care for a child due to school or daycare closure, which is consistent with the amended FMLA, but it also includes caring for another individual with COVID-related illness. Paid sick time is also capped at $511 per day for reasons 1, 2, and 3 that we talked about, and $200 per day for reasons 4, 5, and 6. Prohibited limitations and carryover. So this is interesting and important. An employer cannot require employees to use any paid sick time or other leave they have under the employer's policies prior to using the Paid Sick Time Act. So this benefit is immediately available and will supersede other sick time or time off that an employer may have in its policies if the employee chooses to exercise his or her rights to use this type of leave. And paid sick time does not carry over from 1 year to the next. So it's a use it or lose it type of leave. Notice requirements. The employee is required to provide the employer notice after the first workday that the employee receives the paid sick time. An employer may require the employee to follow reasonable notice procedures. So whatever procedures an employer already has in place for time off, much like the FMLA, even prior to the amendments, an employer can still enforce their notice requirements on employees who are going to miss time due to taking the leave. Same thing applies to emergency paid sick leave. The employers are required to provide notice to employees of this type of leave, emergency paid sick leave. And we had been waiting for several days to see what the notice from the Secretary of Labor would look like, because the Act does state that they will provide a model notice, and we received it yesterday. Many of you have probably already seen this. It is available on the Department of Labor's website, but this is the notice that you will post in the workplace. And again, this leave is going to be available from April 1, when it's effective, all the way to the end of the year, December 31st, 2020. You can expect, if you're a covered employer, that employees will be coming in asking for this type of leave in June, July, and obviously after that. Federal assistance for employers, similar to the FMLA, there is a tax credit that is available to the employers that Gina and Megan will touch on here in just a few minutes. So again, I only put it in here for context so you can see how it fits into the overall statute. Civil liability. I think this is a really important issue for employers to be aware of if they're subject to the Act. Under the statute, the Emergency Paid Leave Act incorporates the Fair Labor Standards Act as part of the enforcement mechanism, and treats unpaid time off under this statute as a failure to pay minimum wages, contrary to federal law. So the significance is, if an employee files a lawsuit and claims they've been improperly denied paid sick time under this Act, they will be entitled to not only the paid sick time, but an equal amount in liquidated damages and their attorney fees. So, for example, if you have a group of employees who said, hey, we're subject to the statute, we want our paid sick time, and you were to deny it to those employees, they could band together. They could file a lawsuit individually. They could band together and file a class action suit like they do with overtime. And in those situations, the plaintiff's attorney is representing these individuals, and the employer's subject to pay that attorney's fees throughout for the duration of the case. And I've defended a number of class action Fair Labor Standards Act cases, and I can tell you they become expensive. But even in the single plaintiff case, the attorney fees can add up very quickly, and often plaintiffs and plaintiffs' attorneys have little incentive to settle if they think they have a good case, because essentially they are paying themselves with the employer's money. Just a quick note on unemployment. Many of you are probably aware of the governor's executive orders. Before the stay-in-place order, she did issue an order dealing specifically with unemployment. I won't read this whole definition, but basically the idea was to cover employees who were laid off as a result of COVID-19 related issues, and it's pretty broad. So that an employee will not be disqualified for unemployment if they were laid off as a result of this pandemic. And then the other thing that's interesting in this order is that the governor stated that an employing unit must not be charged for unemployment benefits if their employees became unemployed because of this executive order. So there is some relief for employers there that if the employees file the claims as a result of COVID-19, that the employer's account should not be charged for those benefits. Now I'm just going to move over to employees in the workplace. I think Another hot issue that's coming up is employees who come to work and say, I don't have symptoms, but I had contact with someone who does, or someone in my house has symptoms, or someone in my household's tested positive. And again, those issues are going to be with you, not just now, not just until mid-April. That's probably going to happen for the next few months, even if once things are opened back up and more employees are returning to work or are in the workplace. And the CDC has some great information on their website on what to do with people who show up either with symptoms or who are asymptomatic and have had reported exposures. So if you have a symptomatic employee who reports to work, CDC guidelines, in conjunction with some recent EEOC guidance that applies during a pandemic such as we have now, allows an employer to send those employees home. So if an employee shows up with symptoms, it's a pretty easy decision. You can send them home immediately. The other more complicated issue is what happens when you have an asymptomatic employee who shows up and describes what their contact is. And you need to figure out, well, is this employee just trying to go home? Is there a serious concern here that they have been exposed and could spread it throughout our workplace? And so what we've tried to do is prepare a risk assessment tool that we use to make it a little simpler. And this is consistent with CDC guidelines, but unfortunately right now the CDC's guidelines are limited to laboratory confirmed COVID-19 cases. And as we all know, very few people are getting increasing day by day. More likely your situation will be an employee shows up and says, I was exposed to someone with symptoms. They have not been tested and they probably won't be tested. So what you need to do is a little investigation and find out what was the exposure. And I'll just go over a couple of key points. If the person was in the same house with the person that has clear symptoms, then you're looking at someone who is going to be a high risk individual or medium risk individual, and they should go home. All right, regardless if they're practicing social distancing and other precautions in the home. If you have an individual who's had a contact and it's not someone they live with, now you're looking at whether or not they have what's called a close contact. And the CDC advises or defines a close contact as someone who has had direct contact with respiratory secretions of a symptomatic individual, or someone who was was within approximately 6 feet of a symptomatic individual for a prolonged period of time. Prolonged period is not defined, but doing some investigation, you have to gather what facts you can, and then make a determination of whether or not there was a quote close contact unquote. I think a lot of times you're going to end up with someone who was an employee who was located in an indoor environment for a prolonged period, but was not within 6 feet or did not have contact with respiratory secretions. Think of a situation where someone's in a large conference room, cafeteria, office building. These people are definitely going to fall in the low risk or no identifiable risk. But again, you're going to have to make sure you're managing that situation. And obviously, if they develop symptoms or more information is learned as far as what their contact may have been, and that may require some additional follow-up. If you do have an employee confirmed COVID-19, this could be a lab test. This could be what they call a confirmed case, particularly with a healthcare provider who states, we cannot get you a test, but based on symptoms, we're confirming that you have COVID-19. You can ask the employee the names of all coworkers, customers with whom they've had close contact in order to identify concerns that you may have with other workers in the workplace, other customers you need to alert of this potential issue. And you want to identify areas in the workspace where an employee was physically present during that 14-day period prior to learning that they were COVID-19 positive. A couple other things you should consider: securing the affected workspace and restricting traffic in those areas, cleaning consistent with CDC guidelines. And there, again, the CDC does have some good resources out there about what is effective in sanitizing a location when there has been potential COVID-19 contamination. If you're in a shared building, should you contact management? I would think so. And a couple other key points, though: do not disclose the identity of an employee. Although we're giving more latitude now by the EEOC and other government agencies to make inquiries into employees' medical issues related to COVID-19, you cannot disclose the identity of that employee or individual to other employees, customers. You have to maintain that. And I know it sounds a little strange, and people may figure it out, but your obligation is to maintain the identity. And again, you cannot disclose medical or health information of a particular individual, even though you have expanded ability to make inquiries now. Under the Americans with Disabilities Act, you cannot disclose personal health or medical information. One side note here: I often hear employers say, well, that's a HIPAA issue, that's a HIPAA issue, that's a HIPAA issue. Unless you're a healthcare provider or an insurance provider, you're probably not covered by HIPAA. And I think, a lot of times employers stress out about whether or not they're a covered entity, and most of the time you're not going to be a covered entity. Doesn't mean you shouldn't take precautions, but it does mean you don't have those risks associated with covered entities. Communication to all employees when you have a COVID positive. This is something you're going to have to think about, manage. Can't disclose who the person is. You don't want to spread misinformation or panic, but you definitely need to alert people if you think there was a real exposure. And if you go back to the analysis of close contact, again, you're investigating. If you find out if was never in contact with several group of people, they're in a separate department, they don't share a lunchroom, there's no risk here, then you probably don't have to inform them. But you're going to have to make some decisions based on the evidence that you gather. And that's all I have. So I'm going to turn it over to Gina and Megan, I believe.
Next, we have Megan. I think you're up. If you would share your screen.
Can you hear me?
Yes, we can.
And what about, can you see my screen?
Yep.
Okay, great. Hi, everyone. I'm Megan, and I'll just jump right in where Dan left off. So Gina and I are going to cover some of the tax benefits provided both pursuant to the Families First Coronavirus Response Act, as well as some other benefits that some businesses may qualify for through the state of Michigan and the SBA. So first up, we're talking about federal tax credits offered specifically through the act that Dan was talking about, the Families First Coronavirus Response Act. So this act mandates that you provide certain types of leave, as Dan detailed, and in order to assist employers providing that leave in paying for that leave, it provides a corresponding tax credit. So the first thing out of the gate to note is that as an employer, you're only going to be eligible for this particular tax credit if you are providing the leave. There's another stimulus bill that we've all been hearing about that's coming hopefully this week, but any of those other benefits you've been hearing about is not what we're discussing now. We're only talking about the credits offered pursuant to this act. So just like there's two types of leave, there's two types of tax credit. They're going to work pretty much the same way. The first credit is for the leave you're required to provide under the expanded FMLA, the sick and paid family and medical leave. So this is going to be a credit. As Dan talked about, it's only if you're off caring for a child who's out of school or out of childcare because of a COVID-19 related reason. So this is 2/3 of the employee's regular pay or $200 a day, whichever is less. And this is capped at a total benefit of $10,000. And the second credit is going to be the credit for the employers providing leave under the Emergency Paid Sick Leave Act. So this has two different amounts. The first amount is the $511 per day per employee for 80 hours or 10 days, so capped at $5,110. This credit is available if your employee is taking leave for the reasons under number 1, 2, or 3. And if you need to go back and look at those reasons, we're going to circulate the slides after the presentation. But if you look at Dan's slides, he lays out the reasons 1 through 6. So we're looking at reasons 1 through 3, which basically is a condition affecting the employee. The other credit is 80 hours of leave at $200 a day or 2/3 of your regular pay. That's for reasons under 4, 5, or 6, which is generally caring for another individual, either a child out of school or a family member who has been impacted by COVID. So to look at those, go back to Dan's slides and you can read the reasons exactly. So both credits are fully refundable. What does that mean? That means that if the amount that you would pay in payroll taxes is less than the credit you're owed, the IRS is going to give you a refund the same way it would give you a regular tax refund. So these credits work a little bit differently when they get access to cash that businesses would need to fund this leave. So it's not going to be a credit against your normal income taxes that if you're a calendar year taxpayer, you would file in April. This is going to be a credit against payroll taxes, which you file on a quarterly basis. The reason for doing that was to get employers access to the cash faster. So if you are on the calendar year, generally you would be filing your first payroll tax return on April 30th. So you could actually, if you had employees taking the leave, you could actually claim the credit on that first return. Now, even the refund coming April 30th, Congress and the IRS understood that this was still going to be challenging for businesses given the current circumstances to implement this. So what can you do to pay for this? You can actually retain all of your withholding taxes that you're required to remit to the IRS. So that includes the employer and the employee's share of Social Security and Medicare taxes. It also includes employee income tax withholdings that the employer would withhold and remit to the IRS on the employee's behalf. So if you're an employer and you've been withholding payroll taxes from January 1st through March 31st, you should have a pot of money essentially that you're waiting to remit to the IRS when you file your payroll return in April. And you can actually use that cash that you are holding in escrow that should be under normal circumstances remitted to the IRS to pay this leave. If that money that you have, your payroll withholdings, is still not enough to cover the cost of providing the leave, the IRS is going to provide a, quote, quick claim form or quick refund form, allowing you to immediately claim a refund, essentially in the form of an advance of the credit from the IRS. Now that form isn't out yet. It was supposed to be out this week, so I would expect it today or tomorrow. So a couple other important things to note. You can use the payroll withholdings from all of your employees, not just the employees that are on leave. The point is that it's freeing up cash that the business would not otherwise have access to pay this leave. So the IRS provides two examples. The employer paid $5,000 in sick leave. It's under normal circumstances would be required to deposit $8,000 in payroll taxes, hasn't deposited those taxes yet. So the employer can use $5,000 to pay that leave, and then it only needs to deposit $3,000 on its next regular deposit date. The second example is the example for if you don't have enough money in those withholdings to cover the cost. So assume you're the employer who now paid $10,000. You only have $8,000 in withholding taxes that you're waiting to remit. You can go ahead and use that $8,000 to make the qualified payments, and then you can request an accelerated credit of the remaining $2,000. So again, as I mentioned before, the process to get that accelerated credit is not certain yet, but we're expecting some guidance on that to come in a very short time. So that was the tax credits. Like I said, it's two separate credits, one pursuant to expanded FEMLA, one pursuant to the Emergency Paid Medical Leave Act. They both are going to be claimed the same way through the payroll with taxes, through the payroll withholding taxes, as well as you can use those payroll withholdings to pay for both types of leave. So other federal tax benefits that exist as of today, hopefully everyone's heard that they've pushed tax day to July 15th. That includes the original guidance had some caps on the amounts of tax payments you could defer, or only applied to payments, not filing. It's now been stated that just assume that tax day is July 15th. So you don't have to file a return. You don't have to make any payment. You don't have to file an extension. Just behave as if tax day is now July 15th. So this does apply to income tax payments that are due April 15th. So that covers 2019 income tax payments as well as for the first quarter of 2020 for any self-employed individuals or any individuals that would normally remit quarterly payments, as well as businesses that remit quarterly payments. So it's any payments that were due April 15th. One important thing to note is that so far, there's been no guidance on the June 15th payment deadline. So prepare yourself that you may still be making your June 15th quarterly payment and then turning around and paying your 2019 tax liability and your Q1 liability on July 15th. So you might have to make back-to-back payments. That hasn't been relaxed yet. If you believe you're owed a refund, you should go ahead and file on April 15th because in advance of April 15th, because the IRS remains committed to processing refunds within 21 days, even throughout this shutdown or stay-at-home order. So the IRS is still working remotely and they're still processing refunds. If you believe you're owed a refund and you've already filed, you can use this link to check on the status of your refund. And this is a link that's always on the IRS website. It's not COVID-19 specific, but it will allow you to check on the status of your refund if you're looking for that cash. So state taxes. Every state follows their own deadlines. Many states follow the federal deadlines, Michigan included. However, Michigan has not issued guidance officially stating that they're pushing the tax deadline. I personally was expecting that Whitmer would announce that today at her address. She did not, or to my knowledge, she did not. So you can use this link. This is a chart put together by the AICPA, which is the American Institute of Certified Public Accountants. They're updating the guidance in real time, and it's got all the due dates for every state. So if you do have filing requirements outside Michigan, you can find their guidance there. Also note, so in addition to federal, state, there's also local taxes for businesses and employees. I use Flint as an example because they have a city income tax, and I thought a number of the attendees to this webinar might be impacted by this. If you normally work within the city of Flint, or the city of Detroit is the same way, you pay taxes for the days that you work in the city. If you're now working remotely, you can and should claim a refund for days worked outside the city. Personally, I did used to work in the city of Detroit, and I worked remotely a lot, so I always claimed a refund for days that I worked outside of the city. So you'll just need to keep track of how many days you work outside the city, and then when you file your return at the end of the year, you can claim a refund for those days, provided that your employer is still withholding the city taxes. And note that only applies if you work in the city but don't live in the city. If you live in the city, then you still owe city taxes regardless of if you're working remotely or at your place of work. Okay, so I think now I'm going to turn it over to Gina to cover the remaining benefits and some of the SBA guidance that we have so far.
Can you hear me right now, everyone?
There we go. Yep.
Very good. Are you allowing me to share my screen, Stephen?
Yep. Go ahead.
It's not allowing me to, but maybe Megan, you can just keep yours up.
Yeah, I can do that if that's easier.
Okay. So first, I also want to make sure I tee up a couple questions for Dan and Megan before we conclude here. And I know, Stephen, if you'll let us go on a few minutes past 3, if that's okay with you, we might need it here to cover these last pieces. Because I do have a follow-up question for Dan as it relates to layoffs before April 1st, as well as whether the executive order related to Governor Whitmer's executive order qualifies under the provision of the first provision criteria for the paid sick leave as it relates to a federal state order in relationship to COVID-19. So perhaps we can swing back and cover those before we leave here today, because I think that's a hot topic for our listeners. Set as well, I also want to clarify one of the items that Megan mentioned, and that is about the ability to retain your Q1 payroll tax withholdings to cover leave for payments. And presumably those would be for paid leave payments as of April 1 and subsequent. So the idea there would be that you have withholdings that you have in escrow that you could then use for these payments that you would be obligated to make for paid sick leave as well as the extended FEMLA. So Dan, maybe we can swing back and have you cover those two topics. So the stimulus package, as many have probably seen in the news today, the Senate voted late yesterday, and we expect there to be a vote tomorrow with the House as it relates to the stimulus package. We just wanted to bring to your attention a couple of items in there, namely as it relates to unemployment items. One of the big items that we see in there is the potential of an additional $600 per week of additional unemployment that could be added to existing unemployment qualification, as well as up to an additional 13 weeks of eligibility. Again, these are proposal. This is what's in the bill right now. I haven't seen the news today as to what type of reaction we're getting from the reaction from the House, but I suspect that we'll be seeing some news even tonight and tomorrow morning on that. The other part that I think is important, because everything that we've been speaking to today relates to the businesses that are under 500 employees. The stimulus package does consider basically large employers as well, which I think is, you can see a tone in there as it is to avoid some of the downfall that we saw with TARP as it related to businesses claiming bankruptcy after the TARP provisions came through. So one of the items that I think is going to be very important to all of our businesses is the ability to postpone payment of 2020 payroll taxes, perhaps to 2022, which would apply to all side taxpayers. Also, as I mentioned, the potential TARP-like assistance for larger employers, but we're expecting that there to be some clawback there as it relates to retaining employees. Megan, if you could go to the next slide. One of the items that I know Tyler Rossmusler is on with us from the chamber this afternoon as well. We've been monitoring this closely, the announcement from the state of Michigan which is administered through the Michigan Economic Development Corporation, the relief program of up to $20 million in both grants and loans for small businesses. My understanding is that there will be an announcement tomorrow at noon, but we have learned that the economic development offices of some of our communities have access to these loans, so we highly recommend, and I'm sure Tyler's phone is going to be ringing off the hook today and tomorrow if it's not already, as it relates to these loan and grant applications. So essentially, for companies with 50 or fewer employees, you can qualify for both grants and loans. The loans themselves are targeted for companies with 100 employees or fewer and cannot access credit elsewhere. So as it relates to the grants, our understanding is that those grants are going to be maxed at $10,000 for companies with employees of 50 or fewer, and that the loans will be maxed at $200,000. And I believe that we had heard originally that the available amounts were from $50,000 and up. We did also hear through a different call that could be as low as $25,000, but those loans will be at a 0.25% interest rate, and they would be funded directly from the Michigan Strategic Fund, as opposed to the way that as opposed to working with a partner financial institutions. We expect the funds to be available, and whether that means that they will be in your bank accounts, we're not sure, but we expect the funds to be available as of April 1st. And as I said, likely funded directly from the Michigan Strategic Fund. It appears that you are going to have to utilize local economic development offices to secure the financing, as opposed to going directly through the MEDC. I'm hoping Tyler will be able to address some details on that, which means working with your local economic development folks is going to be critical to get these grants and loan applications through with the right criteria. One of the factors that we've learned about the loan program itself is that you must be able to show an inability to access credit elsewhere. Now, one of the items that we'll cover on the next slide is the fact that we also have the loan relief program under the Small Business Administration, which is allowing loans up to $2 million for, again, small businesses. The issue is that people are having a very difficult time accessing the small business loan application website. What we've been advising, as well as many of our bank partners have been advising, to be persistent and continue to file. We think it's important that you exhaust all measures, and the SBA loan application is one evidence of demonstrating for the MEDC funding that you are unable to access either adequate or inability to access at all the SBA loan criteria. However, the inability to access the application is not going to be criteria for you to be able to qualify necessarily for the $10 million loan fund through the MEDC. So as I mentioned, the SBA's Economic Injury Disaster Loan application is available for up to $2 million for small businesses and nonprofits affected by the coronavirus. There is an interest rate between 2.75 for nonprofits and 3.75 for small businesses. So obviously the up to 200,000 loan for the MEDC at 0.25 is a very attractive and efficient way to get immediate funds for support. Similarly, though, the loan repayment terms look to be very generous. What I didn't cover as it relates to the MEDC loan program, those are an interest only. Again, this is as it relates to the MEDC funding. The loan is an interest only loan for the first 60 months, and then an additional 60 months for the principal pay down. Switching back to the SBA Economic Injury Loan Program, that you are going to, when you're filling out the application, and also we have access to all of the loan applications that we can send out. If you're unable to access through the website, we can at least get you the forms in your hand so that you can be prepared with all of the data and information that you're going to need, so that when you do finally get access to the website, which the clients that we have had success typically are finding that getting on between 1 and 4 o'clock in the morning seem to have the greatest success in order to get through the website. but you're going to want to select economic injury in order to qualify for this program. And then here, some of what you might expect to be standard information would be your most recent tax returns, personal financial statement, and a schedule of liabilities on your current debts. Again, this is not administered through your bank partners. Now, with that said, in the new stimulus package that we're expecting sometime between tomorrow and the weekend, that we do expect for there to be additional SBA loan financing through your traditional loan partner, bank loan partners. Yeah, but that, again, that's part of the stimulus package. I think that's all we have here today. Do you mind if I flip it back real quick, Stephen, for Dan to maybe answer those 2 questions on layoffs and on the executive order?
Yeah, absolutely.
Thank you.
Okay. Sorry, Gina, could you just briefly tell me what the first question was?
Yeah, so my first question related to, we've had a lot of questions related to if employers have done layoffs before April 1st, and what do the paid leave, new mandated leaves, do they apply, and how do they handle that situation?
So based on the recent DOL guidance that we're getting, and it's coming in the form of Q&As that are published on the Department of Labor's website, anyone who was laid off prior to April 1, 2020 will not be eligible for the benefits in either the expanded FMLA or the new Emergency Paid Sick Leave Act. And so, if you had an employee and you laid them off, and the facts indicate a separation of employment, those folks will not be eligible for any type of paid sick leave benefits or the FMLA. If you have placed individuals on some type of leave, a temporary leave, a paid leave, allowed them to use PTO or other sick time that's available, and did not take action that resulted in a separation, extending a COBRA letter, then it's possible those employees are still the ability to claim those benefits after April 1. But some of it will depend on the facts of each case to determine whether or not the person is actually employed as of April 1.
Thank you. And I think the other question, Dan, as it relates to, and I know there's a difference of opinion and it's going to be based upon the circumstances, but as it relates to Governor Whitmer's executive order and whether that is one of the criteria as it relates to the paid sick leave for the federal state order due to COVID-19.
Okay, so as of April 1, 2020, remember that none of these benefits would even apply until April 1, 2020. So as of that date, people in Michigan will still be under a stay-home order. And the question is whether or not that qualifies as an employee who's subject to a state quarantine or isolation order related to COVID-19. And there is some debate or dispute in this area, and it's not entirely clear. There are some that say the order itself says employees must stay home, period, identify some exceptions. That's an isolation order. Others say, no, it's not. Isolation order is for someone coming off a cruise ship or a plane from China, and they're being sent to isolation centers. So there's it's not entirely clear. Maybe we'll get some more guidance when the DOL, the Secretary of Labor, releases the regulations that we're waiting on. But right now, it's not entirely clear, although, it appears, I think many people feel like they've been isolated if they're subject to one of those stay-at-home orders. And so I think a compelling argument can be made that anyone who's subject to the stay-at-home order would qualify under the first bucket of the Emergency Paid Sick Leave Act.
Thank you, Dan. Yeah, that's perfect. Thank you. Steve?
We do have one question so far. It is any guidance on residential taxes for Genesee County municipalities.
You mean property taxes? Is that what residential taxes mean?
If the person who asked that question, if they want to further clarify, but I'm going to assume yes.
I have heard nothing on property tax payments being delayed. And given we have no Michigan specific guidance really at all, so unless Genesee County has issued something specifically that I'm not aware of, I don't think there's any property tax payments delays at this time.
Any other questions from our attendees before? Oh, here we go. Yep, they clarified residential taxes.
Gina, I have a question. Could you explain the unemployment was said up to $600? Is that in addition to the Michigan 360 something, or is that $600 includes the $300 discussing?
I'm not sure if I heard all of that, but I think it related to the stimulus package, Tyler.
Yeah, sorry if I was breaking up. I'm referring to the $600 of unemployment, and how does that include or not include the 300 and some odd dollars from Michigan?
Yeah, my understanding is that that's exactly what's being debated today in Washington, D.C. I don't have a good answer for you there other than that the amount was as much as 600, but my understanding it would be incremental to the Michigan unemployment, 362 per day per week.
Yeah, I think that's how it was written, and there were senators coming out late last night saying there was a glaring drafting error in the bill. So I think that's might be something that goes away, because I know Lindsey Graham from South Carolina, I saw last night saying that in South Carolina you would get like $24.75 an hour in unemployment, which is well in excess of what the average hourly worker makes. So I don't think when we see a final bill that it'll be all the way up to that $600 as it was initially written.
I agree.
I'm not seeing any other questions from our attendees.
If it's okay, Stephen, I could just give a brief echo to what Gina covered on the local MEDC grant program.
Yep.
Sure. So on flintandgenesee.org on our website, we have the Small Business Relief Program, our tab. There you can find more information, really what Gina discussed as far as qualifications for the businesses, both for the grant and for the loan program. And you can get the application at that site. Other than that, we're happy to answer questions. You can reach out to any of the contact information that's on that site. Reach out to me, to Stephen, or to Tracy Joseph, and we're happy to help.
And will you just mention we're doing one of these tomorrow, 10 o'clock?
Tomorrow we're going to go over that application. The thing that is very confusing is that the state gave an Excel file. And so if you do get that Excel file, just note that there are multiple tabs that have to be completed, not just the first tab you see when you download the file. That's the first kind of pro tip of the day.
Tyler, for the pro tip.
Yeah.
If there's nothing else, I'd like to say thanks to all of our panelists, Howard and Howard. Is it safe to assume that any of our attendees can reach out to you directly with that info shared?
Absolutely, and we will forward our materials on to share with all of your membership or your listeners for sure.
On our site, flintgenesee.org/toolkit is where our hub lives for all of this information. We'll get this webinar and materials posted up as quick as we can. And if there's nothing else, thanks for joining us. Have a great day.
Thank you.